Langer AJ from Johannesburg High Court, CK versus J.J.S, ZAJGPJHC, ZAGPJHC, that is a mouthful, 292. And this is a local relocation where the applicant wanted to relocate within South Africa from the Greater Johannesburg area to Belito, just down the road from where I am at the moment. The court looked at the best interest of the child standard in terms of Section 7 of the Children's Act, and the court looked at the provisions or the requirements for a relocation. This judgment was part of a Part A, Part B, as we very often see in the case of relocation matters. Part A was essentially to get an expert appointed. Part B is then the actual relocation. Part A was unopposed. There were investigations by the Office of the Family Advocate and a clinical psychologist in respect to the best interest of the child, and the judgment, obviously. Part B was then set down for hearing before Langer AJ in the Johannesburg High Court. For those of you following along, page 21 in our summaries, page 353 of the bundle. The court essentially said, look, there are justifiable reasons for the relocation. If we look at paragraph 6 to 7, the court weighs up. At the hearing, counsel submitted that the legal test for relocation matters is the reasonableness of the decision to relocate and whether the relocating parent's decision is bona fide. Absolutely. The applicant listed a number of factors which she took into consideration for relocation. There's no doubt in my mind that the decision was taken in a thoughtful manner, and the applicant's decision had nothing to do with creating distance between the respondent and the minor child, obviously making it a bona fide decision. Likewise, the respondent has justifiable reasons for his refusal to agree to the relocation, and this court sees nothing to censure the respondent in his dogged refusal. The ratio of the court in paragraph 13 turns on the best interest of the child standard. I cannot escape the conclusion that forcing Jay to relocate will not be in his best interests. Professor Pretorius's report makes it clear that they are equally bonded to both parents, and forcing him to leave Johannesburg will negatively impact on his relationship with the respondent. Electronic contact and alternative weekends do not make up for the lived experience of seeing both parents weekly. In this instance, obviously, the relocation application was dismissed. That was CK versus J.J.S, Johannesburg High Court, ZAGPJHC 292, under the pen of Langer AJ, bundle page 21, or summary page 21, bundle page 353, and it is a 6-page judgment.